ऐसे और वीडियोस के लिए मेरे चैनल को सब्सक्राइब करें। 3, 2, 1, स्टार्ट।
Indeed, in paragraph 17 of the reported decision, the court, in the facts of the case, has observed that when the goods are kept in the bonded warehouse, it cannot be said that the said goods had crossed customs frontiers of India. However, the court finally answered the claim of the appellants therein on the finding that the liquor, cigarettes, perfumes, and food articles were sold at the duty free shops at the International Airport, Bengaluru, for which no tax was payable by the appellants, as the goods sold at the duty free shops were sold directly to the passengers, and even the delivery of goods took place at the duty free shops before importing the goods or before the goods had crossed the customs frontiers of India. The issue considered in the said decision, therefore, was whether the sale at the duty free shops situated at the Bengaluru International Airport would attract levy of sales tax. As noticed earlier, the definition of customs station clearly refers to customs airport as defined in section 210 of the Customs Act. As the duty free shop is situated in airport area, it would mean that the sale of goods at the duty free shops was deemed to have taken place in the course of import of the goods into the territory of India. Thus understood, the reported decision under consideration is of no avail to the appellants. Even the exposition of the Constitution Bench in J.V. Gokal that a sale by an importer of goods after the property of the goods passed to him, either after the receipt of the documents of title against payment or otherwise to a third party by a similar process is also a sale in the course of import, would equally have no bearing on the present cases, inasmuch as the sale of goods must take place before the goods had crossed the customs frontiers of India, which meant it was within the customs port or land customs station area. Nothing is shown by the appellants herein to substantiate that the subject bonded warehouse came within the customs port or land customs station area, and more so, the stated sales occasioned imports of the goods within the territory of India. If so, the finding of fact and conclusion recorded by the authorities below, which commended to the High Court, is unexceptionable. This court has expounded the factors to be reckoned for determining this matter. In the light of the aforesaid settled legal position emerging from the Constitution Bench decisions of this court, the following propositions clearly get projected for deciding whether the concerned sale or purchase of goods can be deemed to take place in the course of import as laid down by section 5(2) of the Central Sales Tax Act as 1. The sale or the purchase, as the case may be, must actually take place. 2. Such sale or purchase in India must itself occasion such import, and not vice versa, that is, import should not occasion such sale. 3. The goods must have entered the import stream when they are subjected to sale or purchase. 4. The import of the concerned goods must be effected as a direct result of the sale or purchase transaction concerned. 5. The course of import can be taken to have continued till the imported goods reach the local users only if the import has commenced through the agreement between foreign exporter and an intermediary who does not act on his own transaction with the foreign exporter and who in his turn does not sell as principal the imported goods to the local users. 6. There must be either a single sale which itself causes the import or is in the progress or process of import, or though there may appear to be two sale transactions, they are so integrally interconnected that they almost resemble one transaction, so that the movement of goods from a foreign country to India can be ascribed to such a composite, well integrated transaction consisting of two transactions dovetailing into each other. 7. A sale or purchase can be treated to be in the course of import if there is direct privity of contract between the Indian importer and the foreign exporter, and the intermediary through which such import is effected merely acts as an agent or contractor for and on behalf of Indian importer. 8. The transaction in substance must be such that the canalizing agency or the intermediary agency through which the imports are effected into India so as to reach the ultimate local users appears only as a mere name lender through whom it is the local importer come local user who misled. It will also be useful to advert to paragraph 6 of Kiran Spinning Mills, which reads as: attractive as the argument is, we are afraid that we do not find any merit in the same. It has now been held by this court in Hyderabad Industries Limited Union of India that of levy of additional duty can be imposed.